Hey everybody, Stephen Key here, and today I want to talk about when do you file a patent. I know what it's like when you come up with this idea and fear takes over. Is someone going to steal my idea? And I'm here to tell you, just take a deep breath, you guys. 25 years ago, that fear hit me, and sure enough, I went out and I filed 2 patents. And those 2 patents were about $15,000 a piece. And what I realized, because of fear, when I ran out and I filed those 2 patents, I filed them too early, right? And they became worthless. And I thought, like everybody else thinks, that's the first thing I need to do. And I'm here to tell you that's not the first thing to do. You see, I'm a big patent holder, as you can tell behind me. I have over 20 patents in my name. I've even defended my patents in federal court against one of the largest toy companies in the world. And that was painful, but I learned a great deal about when do you need patents, because you don't need patents on every idea. If you have a really big idea, you're going to need multiple patents. And that's what you see with the patents behind on this wall back here, is that I had a big idea called spinformation, and it required a lot of patents. But most ideas don't require a wall of patents. Patents aren't for every product, you guys. It's just not. For some big ideas, patents are very important. But for most of us, we're going to have small ideas, and we don't need patents. But what we do need is perceived ownership. And you can get that perceived ownership with a provisional patent application. Provisional patent applications are one of the most wonderful tools for us people with creative ideas. It gives you patent pending status for 1 year, very affordable to get one. In some cases, it's only $65 to file one. The USPTO does not even open it up. And guess what? Putting patent pending on your idea gives you enough perceived ownership to license those ideas. Now, recognize you have to write your provisional patent application in such a way that it has value, and only you can do it. I wouldn't have a patent attorney write this. Maybe after you write it, they review it and maybe write it for you. But I can show you how you can become an expert. I'm not a patent attorney. I cannot give legal advice, but I have filed for many, many patents. I understand this process from a business perspective, not from a legal one. So here are a few of my tips. Number 1, there's going to be a lot of people that are going to tell you, file a patent, you need to protect that idea. And I don't want you to, out of fear, rush out and file a patent, because I mentioned earlier, I made that mistake and I learned a lot along the way. Realize that 97% of all patents never make any money. So something's wrong here. And I'm going to go through some of the steps for you to determine, number 1, do you have a marketable idea before you spend all that time and energy on patents? Now, how do you write a provisional patent application that has value? Let me share with you. This is extremely easy, and you can become the expert really, really fast. To become the expert, you need to do 2 things. The first thing, do a Google image search. Try to find your idea and see if it's out there. Become an expert in your micro category. You're going to learn a lot. Also, that's going to allow you to put a list of potential licensees together if you go forward to call them about licensing your idea. The second thing you need to do is to learn how to search for prior patents. It's not that difficult. You can do it 2 ways. You can go to Google Patents, type in similar words, and sure enough, you'll find patents out there that are close to your idea. I can guarantee it. But you still want to find your uniqueness. Always look at the drawings first. If it looks like it's really close, start reading the whole patent. Now, you can also do the same thing. You can go to the uspto.gov and look for prior patents. It's a little harder to navigate, but those 2 sources is where you want to look for prior patents. Now, you guys, you're going to find something similar. I can guarantee it. Don't panic. Find your uniqueness. Look at the drawings first, then read the claims, and then read all of it. If it's so close to your idea, that's not the end of the world either. You might be able to reach out to that inventor Ask them what happened, because you've already checked and that idea isn't out on the market yet. So something went wrong. Try to figure it out. Call that inventor and ask them, hey, I'm a consumer. I love your idea. What went wrong? Listen to his story, and most likely he's going to tell you a couple things. He didn't have the money, or maybe it was too early, or maybe he just didn't know what to do. But he's got a very expensive plaque on the wall, and he would probably welcome your call for you to try to find a licensee for him. You can work out the deal, contact a licensing attorney, drop a one-page, how do you guys work together, you share in the royalties, very simple to do, but that's what you do if you find something that's exactly like yours and you still want to go forward with it and it's not on the market today. Okay, so next what I want you to do, you've done your homework, you've done your Google image search, you haven't found your idea out there, you've found other ideas that are similar, and what's really great about that, now you can make your list of companies that you're probably going to submit to. Right? Know your point of difference. Know your uniqueness. Second, you've done your prior art searching, and guess what? You found some ideas that are kind of similar, but not exactly. You found your uniqueness. So when you write your provisional patent application, you're going to write it in such a way that now has value. Also, you guys, what's really important too, when you write your provisional patent application, and you can do it yourself, there's no requirement of legal speak. You don't even have to put claims in it. What's really wonderful about it, you're just going to tell your story. And there's a certain format of a provisional patent application. You can read a lot about it, but it's really simple, you guys. There's field of invention, right? That's basically an overall picture of the industry. Make sure you don't put your invention in the field of invention, because then it would be prior art. Second is the problem. What problem are you having or other people have that you're solving? So state the problem. Next is the solution, your invention. What is it? And make sure you describe it in great detail. Maybe some of the material, maybe how it could be used. Tell as much as you can, especially from all the things that you've gathered. Maybe you built a prototype. Maybe you know what works. Maybe what doesn't work. Do your homework, know more about it than anybody else. Next will be the summary. You're kind of bringing everything together, and then the drawings. The drawings are extremely important to me. I love the drawings because a drawing's worth 1,000 words. Make sure you can put photographs, but don't do the photographs, you guys. Take the photographs and have someone turn those into line drawings. They don't need to be professional patent drawings, but tell your story. And I also, sometimes I'll do a flow chart. You do this, you do this, you do this. And I do this with drawings. I tell a story. It's almost like instructions that you get when you buy something and you have to put it together. It's just like that, right, you guys? So a provisional patent application is something you can do yourself. The United States Patent and Trademark Office doesn't even open it up when you file it. And it gives you 1 year to see if you want to go ahead and file a non-provisional patent application, right? You're going to realize that you can be the expert. You can write a provisional patent application that now has value. Value to your potential licensee, value to your attorney, or maybe their attorney when they want to turn this into a non-provisional patent application, meaning a patent. But you didn't rush out and file a patent at first. Most big ideas might require a wall of patents, but most other ideas do not. In fact, a lot of ideas go in and out of the market so quickly, it doesn't matter if you have a patent or not. It's not about protection. It's about selling. This whole topic is really, when do you file a patent? And I'm saying this, don't rush out with fear and file a patent right away. Do your homework first. And if you do the things I just talked about and you decide to file a provisional patent application, it's easy to do in most situations. It's only $65. Very, very simple tool. It gives you that perceived ownership that when you reach out to other companies, potential licensees, it's enough for them to sign a licensing agreement. All the licensing agreements that I've seen over the years, in fact, over 15 years, no one has a patent. It's all because of this great tool called a provisional patent application. It gives you the perceived ownership you need to sign the licensing agreement. Check it out, you guys. Take a deep breath. Don't panic. I know there's that fear out there, but use a provisional patent application as your tool to move forward with your ideas. Thank you.